Welcome to Illinois Law. My name is Marty Dolan and I'll be your moderator for today's show. Our topic is environmental issues in rented property. Our guest is Gene Schmickens, a member of the Business Services Practice Group at Evans and Dixon in St. Louis. He represents clients in environmental law issues including compliance enforcement, administrative litigation, insurance, permitting, transportation requirements, and transactional issues arising out of the sale of real estate businesses. He is a frequent lecturer and author on a wide variety of environmental issues. Gene, welcome to the program.
Thanks for having me.
Gene, just getting right to the heart of the issue, can a business owner be responsible for environmental issues that existed on a rented property that a business didn't cause?
Absolutely. Superfund law makes 4 classes of people liable. The first is current owners and operators of the property. So an operator can be someone that is just, the plain language of the word operator is someone that operates a business on that property. There's no requirement that they be a title holder to the property, so a leasehold interest in a property can give rise to Superfund liability.
If environmental problems surface in a rented space, can the business owner terminate the lease, or what things happen at that point?
That's strictly a contractual issue, and clearly if it has something to do with whether or not they caused the problem.
Right.
But the important thing to remember is that there is an opportunity for that business owner to insulate themselves from Superfund liability.
Okay.
In 2002, the law changed, and it created a new bona fide prospective purchaser defense. EPA recently came out with a guidance document that said that a lessee has the same opportunity to assert that defense as the title holder of the property.
Okay.
But they have to go through the same steps that property owner has gone through. So if the property owner did everything they were supposed to do and they have the status as a bona fide prospective purchaser, then the lessee can piggyback on and take advantage of that. However, if the owner loses that and the lessee didn't go through the same steps themselves, then they lose that defense.
Okay. So essentially a lessee has the same rights as an owner in that perspective.
That's correct. And they can also, they can also establish that on their own by doing a Phase 1 report before they take over the lease, and then if they have continuing obligations based upon what they know and what they're doing at the property.
Does the owner have any notice requirements to the lessee if there's a known issue or something becomes known?
That's a property law question, and they're, just the same disclosures that would apply to property would exist at the same point. Now, I can tell you, when I'm doing a lease on behalf of a client, I ask for all the environmental or any environmental studies that have been done, and I also recommend to my clients, if they're doing a lease, to go ahead and do their own Phase 1 report.
Can you give us some examples of some adverse environmental issues that someone might encounter in a shopping center or a business district?
Sure. Shopping centers, it's real common. A lot of times you had dry cleaners that operated in a strip mall, and it's not uncommon to have a release from those dry cleaners of perchloroethylene, which is the common dry cleaning solvent. So you can have someone that goes into that space afterwards, and suddenly, they're liable for the cleanup of the release of TCE. It's also, you see a lot of, franchises that go into the old corner drugstore, the old corner lot, which at one time held a underground storage tanks, a gas station or something like that, so you get to release underground storage tanks.
Okay.
Then depending on the age of the strip mall, you may have issues with respect to lead paint or asbestos or something like that.
What kind of advice would you give to a prospective owner to protect against liability before any lease is signed?
Well, the first step, as I said a little bit earlier, is
Inspection.
to do a phase, inspection, do their own Phase 1 report, do an inspection of the property themselves. I would also always ask the landlord to provide any Phase 1 reports or any other environmental reports that may have been there. But if you do your own Phase 1 report, you're going to look at the history of the property, you're going to look at prior records, you're going to look at prior lessees, you're going to look at what was there before You know, I mean, you may have a new strip mall,
Right.
but that doesn't mean that there weren't environmental issues beforehand.
Are there other steps that a business owner should take before signing a lease, whether it's on the insurance end or anything else that you would recommend?
You know, depending upon what you might find in your normal due diligence, you know, that's the great thing about environmental law is there's no one right answer. So it's really a site-specific issue. I would say that certainly insurance may be an appropriate vehicle, depending upon, you know, the property. You know, a lot of these rehabbed areas in the Chicago area, certainly it may be worthwhile to have some insurance. You know, not always. There's possibility exists you could be a named insured. But you know, overall, the best defense is to do your due diligence up front and not get yourself into that mess.
Conduct the inspections that you recommended.
Precisely.
Okay. Gene, thank you for coming to the show today. We appreciate your advice.
Thanks.
This is Illinois Law. Have a good day.